If your name is not stated in the will of your family member, does that still give you the right to claim some maintenance from them? The case of Hirachand says yes to this answer, but it also shows that what you can sue your family member for is limited. The case combines two very complex areas of law: the Inheritance Provision for Family and Dependents Act 1975 and the conditional fee arrangement some people call a success fee. The deceased left his whole estate of about 554,000 to his widow, and their daughter and son took nothing. To add some sympathy to the daughter's position, both the daughter and the widow had health problems and needed the money for their own well-being. So, the daughter brought a claim, advised by solicitors, under the Provision Statute, the 1975 Act, claiming what we call in law reasonable financial provision. She actually succeeded, with the judge giving her about £140,000 in reasonable maintenance fee, and interestingly, adding about 16,750 as a 25% markup to cover the success fee that she has to pay. This is what makes the court a point of law that went to the Supreme Court. You see, the daughter entered into an arrangement with the solicitors that if she won her case, she would have to pay them an additional 72% of their base cost fees. Mathematically, if the solicitor's fee of base cost was £10,000, she would now have to pay 72% of £10,000 on top of that. The effect of this is, as stated in paragraph 12, that the widow was ordered to pay directly cost of 80,000 to the daughter and indirectly out of the estate of which she was the sole beneficiary, 16,750 towards the daughter's success fee. So this raised some alarm bells. The major alarm bell was whether this kind of award made by the judge would end up murking the waters between damages for compensation and costs, which are typically separate regimes in the law. To cite Lord Richards in paragraph 56, leaving aside success fees, there has never been any suggestion, save in one case referred to below, that the general principle whereby costs are dealt with in accordance with the CPR and are not recovered by means of the substantive relief does not apply to claims under the 1975 Act, nor is there any reason in principle why that principle should not apply. If the court orders the claimant's costs to be paid by an unsuccessful defendant, such costs to be accessed on the standard basis, it would, to adopt McGregor, a commentator, at paragraph 22-003, make nonsense of the rules about costs if the successful party could recover by way of the substantive award the amount by which the assessed cost fell short of the cost payable on a solicitor and client basis. It is important to note the part about making nonsense about costs. The point that they are trying to make is that if the costs and damages regime are murky, it would allow for dangerous consequences such as parties suing for costs disguised as damages, because after all, the judge awarded the cost amount under a claim for the 1975 provision, which is a claim for money for compensating the fact that she wasn't included in the will from one point of view. And if this is murky with costs, it invites other private rights of action that would try to claim for success fees as well as part of the damages when it actually amounts to a cost. And there's also a parliamentary statute, importantly, section 58A, subsection 6, which states that costs cannot include any success fees under any conditional fee arrangements. So a further problem that the court was worried about is whether such a award would allow claimants to override Parliament's intention. So ultimately, the case preserves an important distinction between damages and costs, that they are separate regime, and the cost regime is only there for the winning party to recover what they incurred as part of their litigation, not to help reduce the cost of their success fee, which is banned under the parliamentary statute from compensation. Any thoughts on this case? This was a long one. Follow for more law updates.